Okay, I'm going to share the screen. Number 19. Number 19. Uh-oh. Wait a minute. Wait a minute. I got a feedback. So I gotta mute you. Okay. Now. There you go. Now I'm stuck. Okay. Let me see. I think I got stuck again. Okay, hang on. Okay. Now I'm gonna share the screen. Okay. B, you see it, B?
Yeah, I see it.
All right. Here we go. So when the proctor say go, then you do the first thing you do, okay?
Okay.
Now, you're gonna do the whole thing from A to Z.
Okay.
And the purpose of it is we're gonna try to strike the wrong answer.
Okay. If the
Okay, go.
If the court rules that the sublessee is not liable to the landlord for the unpaid rent, what will be the most likely reason? And so I would underline sublessee because that's a bit of a
Okay, wait. I guess. All right. Okay. I gotta go annotate. Okay. All right. Now, let's do reaction. Do it again. 1, 2, 3. Read the call to question.
If the court rules that the sublessee is not liable to the landlord for the unpaid rent, what will be the most likely reason?
Okay. Go ahead.
Okay, so the umbrella is landlord. I see landlord tenant, and then I also see a sublessee. So we're probably going to see somebody, a tenant sublessee to a third party and whether they're liable to the landlord.
Good. So I make a mistake that I did that for you. You tell me and I draw it for you. Okay.
Okay.
All right. Now so now you know it's landlord and tenant and a sublessee.
Yeah. So I go to A. A sublessee is responsible to the landlord only as a surety for unpaid rent owed by the tenant. That's not. I would underline sublessee, underline landlord, and then only a surety. I don't think that's a true statement of law.
Okay. What should we do here with A?
I would strike it.
Why?
Because that's not true.
Why it's not true?
The sublessee is not a surety to the tenant. If anything, then the tenant would be responsible, and then to the landlord because of privity of contract. If the sublessee has rented for the entire period, then he's also responsible. They're both on the hook.
Okay. You're not quite there. The reason you want to strike A is the word surety. What does the word surety mean?
A guarantee,
Guarantee what?
a guarantee that the sublessee would pay to the landlord, but the sublessee didn't make any promises to the landlord, I don't think.
No, a surety then it's a statute of fraud.
Oh, okay, yeah.
Okay, surety means a statute of fraud. It's a guarantee, right? My legs is a guarantee and a surety. So this is a landlord and tenant questions. Surety is not going to test in the landlord and tenant.
Okay.
A sublessee never a surety. for the landlord or for the tenant, never surety. Okay, it could be a landlord and a sublessee, could be a privity of contract, it could be a privity of estate. That's why each party liable to each other. A surety is not a term of art that would the bar examiner would test you on this landlord and tenant.
Now I understand. Okay.
So strike A.
B, the sublessee constitutes a novation, or the sublease, sorry, constitutes a novation of the original lease. So sublease and novation.
Okay.
And I mean, unless they sign a new contract, that's not true, right? Or if the landlord agreed to let the tenant off the hook, will it be a novation?
Okay. I don't see your brain. Okay, your logic. When we read a sentence, when we read a sentence, we're gonna find terms of art.
Okay.
And then we define the terms of art in our brain.
Okay.
And relate it to this the umbrella, which is landlord and tenant.
Okay.
So here a new word could be a sublease, and we know landlord and tenant they do that to each other. Okay, to the sublessee. But here's a word novation. What is a novation?
It's a new contract. So it cancels an earlier agreement.
Okay. Now, do you think? Okay.
I'm so sorry about my dog. Give me 1 second. Let me let her out. Okay. Sorry about that.
No problem. So you know the novation is you have a contract, then you kill that contract, you went on and get a new one kill the old one, that's a novation. All the terms, all the rights and all the duties of the old contract are gone. So there's a novation, right? So do you think landlord tenant let someone get out of an obligation? Do you think a landlord would let someone get out of obligation? Probably not. But it could be stupid enough. But when we read the fact, it doesn't mention those kind of novation, then B will be wrong.
Okay.
You see it? So right now we're not sure. Okay. So a sublease, actually a sublease never a novation. Now we know now too. A sublease is what?
You're leasing.
Don't know if the landlord let him in. Okay. We don't know. But we know a novations is you have an original contract, and then you have a second contract. A second contract kill the first contract. But if the second contract doesn't kill the first contract, then what do we call that?
If the first contract doesn't kill the second?
No, if the second contract doesn't kill the first contract.
Novation, so a sublease.
No, it's an accord and satisfaction.
Oh, okay.
The yin and the yang is the novation and accord and satisfaction. They go together. Okay. Accord and satisfaction, which is the second contract, but the second contract doesn't kill the rights and the duties of the first contract.
And then they could sue on either one, right? If they don't.
Correct.
Okay.
Correct. So we leave B there.
Okay. C, the sublessee is not in privity of estate or contract with the landlord. Well, I would underline sublessee, not privity of estate or contract, and that's not true either because the sublessee at some point would be in privity of estate, correct?
Well, that is the general rule. That is the general rule, right? So a general rule is a rule. You cannot strike it because it's a general rule, right? So the only thing here is not. Okay, so it seemed like the novation word. So this is need more fact.
Okay.
So if the sublessee never have a privity of contract or privity of estate, so we have to read the facts on that.
So in what situation would the sublessee not be in privity of estate if he's no longer in possession of the land? He's off the hook?
Hey, okay, so we let's talk about that. We know most of the time the sublessee doesn't have a privity of contract because the privity contract is between the landlord and the tenant, or two original parties. So a sublessee is if he move in, he will have a privity of estate. He will have privity of estate. Here say it's not, so we have to read the facts.
Okay. D, the sublessee's rent payment to the tenant fully discharged the sublessee's obligation to pay rent to the landlord.
What do you think that? Well, oh, I'm sorry, I underlined it for you. What do you think?
Yeah, sublessee's rent and then discharge, obligation to pay rent to the landlord.
Is that a true statement or is that a false statement?
False statement.
Huh?
I think it's a false statement because his obligation to pay is to the landlord, not to the tenant.
If he is have privity of estate, right? But a sublessee always have a duties to pay to the landlord.
Right.
So if the sentence say the sublessee rent payment to the tenant fully discharged.
No.
No, right? That statement can be false, right? So D is gone.
Okay.
Okay. So now
to the top.
To the top.
A landlord leased a building to a tenant for a 10-year term. Landlord, building, and then tenant. 10-year term.
Okay.
2 years after the term began, the tenant subleased the building to a sublessee for a 5-year term. 2 years after, tenant subleased.
Okay.
5-year term. Under the terms of the sublease, the sublessee agreed to make monthly rent payments to the tenant. So sublessee agreed, and then rent payments to tenant.
Okay.
Although the sublessee made timely rent payments to the tenant did not forward 4 of those payments to the landlord. So sublessee timely payments and tenant did not forward.
Okay.
The landlord. The tenant has left the jurisdiction and cannot be found. The landlord has sued the sublessee for the unpaid rent. Landlord sued sublessee.
Okay.
There is no applicable statute. If the court rules that the sublessee is not liable to the tenant for the unpaid rent, what is the most likely reason?
Okay.
B, the sublease constitutes a novation of the original lease.
Okay. Now,
D,
when you read the first 5 patterns, did it has
no novation.
anything to do with first contract, second contract? Wrong.
The sublease is not, sublessee is not in privity of estate or contract with the landlord.
Okay. So we know that sublessee not in the privity of contract with the landlord. Is the sublessee here or is the privity of the estate with the landlord?
Yes, because he's in possession of the building.
No, he didn't.
No,
Because you didn't even look at this sentence. The tenant has left the jurisdiction.
but that's not the sublessee. That's the tenant.
Yeah.
Does that matter?
Oh, okay. Oh, I thought it was the I thought it was the sublessee. Oh, okay. No. No. All right. The sublessee make rental payment. The tenant did not forward. The tenant has left the jurisdiction and cannot be found. The landlord has sued the sublessee for the unpaid. Oh, okay. Well, look at the call to questions.
If the
Read the call to question again.
If the court rules that the sublessee is not liable to the landlord for the unpaid rent, what will be the most likely reason?
Okay, here we go. The most important word in this sentence is if.
Mhm. So they made a decision, okay?
If is a it's a hypothetical example. If the court rule it.
Mhm.
First of all, this is the only one, is the best one right here. Why would the court here rule the sublessee win? Well, if the sublessee doesn't have a contract, a privity contract with the landlord, the sublessee win. If the sublessee doesn't have a privity of a contract with the landlord, the sublessee win. That's why C is correct.
I would have picked D, Mr. V.
You
But
pick D?
Fully discharge is the wrong. Yeah, I would have picked D.
Okay, read D for me.
The sublessee's rent payments to the tenant fully discharge the sublessee's obligation to pay rent to the landlord?
No, because the sublessee is it have a privity of estate. Okay, privity of estate. What is privity of estate means?
That he's in possession of the building, right?
Yeah. So he didn't pay the landlord. So in other words, the sublessee paid to the wrong person. So sad and so bad.
Oh, really?
Yeah. You occupy my land and you pay to someone else.
Yeah.
So you see what I'm saying? You gotta find who is the duty that you owe to. So D is wrong.
Okay.
But this is a very good difficult case. This is pretty difficult. I thought the lessee, the lessee, the assignee move, but it's not. It's a tenant. That makes it even difficult. But it's because we know for sure that novation is not it, right? And we know for sure surety is not it.
Mhm.
So it's only C and D left. So, and then this is another trick that the board examiner trick you. Whenever you see the word if ahead of everything, it make the following words a true statement.
Mhm.
Write that down.
Okay.
I don't care how ridiculous it is, but that statement followed by the word if is true. It is true that the court rule that the sublessee is not liable.
Mhm.
Okay, I don't care how the fact pattern work, but if the word follow that will make that sentence true. So you gotta hold You got to hold that statement true. So now, which sentences here will make if the court rule that a surplusage is not liable, which rule will make the call the question true? Which one?
Well, C, because he wasn't in privity of estate or contract.
Yeah. How can the landlord ask someone to pay rent when the or when that person never have privity of a contract or never have a privity of estate? Therefore, C will make the statement here true. Wow.
This one was tricky for me.
Right. Now, also, B, when you read sentences, you don't, a little while ago, you underline a lot of things.
Okay.
You can't. When you read, you underline terms of art. Okay. You underline words that trigger things. Words is important. And as a lawyers, we know some word that we must pay attention to. And those words I teach you, remember? Like dates and terms of art and year, money, those kind of things. Okay. The rest you cannot underline it. Otherwise, you little while ago you underline a whole bunch of stuff.
Everything.
Yeah, it's like everything is important to you.
Yes, I have problems underlining everything.
Then it's messy.
Yeah.
Right. So when you read it, you always, it's one of my rules, you always circle the landlord, the party once.
Okay.
Okay, so here's the landlord, you circle once. You don't need to circle when you come down here. Okay, you have to keep that on your mind. And then you circle the tenant here and circle it once. The reason we circle the parties is we know how many parties there are. Then you got to pay attention. The board examiner interject a third party that is really irrelevant. It doesn't have to do with the contract. It's like the neighbor. The neighbor tell the guy, the buyer something. Well, the neighbor is not really an interesting party. You still circle him, his name, but be careful. It may be just irrelevant.
Okay. So here, what would you have underlined that I wouldn't have? Or okay, so like on the first sentence.
Okay. Here's the way I would do it. Okay, very good, B. So I would read the call the question, and I would underline the word a circle court. Remember, one of my rule is the bar examiner always put the word court in there, and they make the court as a party. Okay, so if the court rule that the sublessee not liable the landlord for unpaid rent, I don't even do unpaid rent, because that we just know that is under the umbrella. Rent is under the umbrella of landlord and tenant. Okay, what will be the most likely reason? So I like the word most likely reason. So which one is the strongest one? Most likely. Okay, and then I read a sublessee is responsible to the landlord only by surety. And I stop here. I would look, this is a term of art, and I would bring in my brain, say surety, that's a statute of fraud. Okay, but it has to do with guarantee, some kind of thing. So surety is not really in real property. Surety will test you on surety will test you on surety will test you on contract, like your child go buy a car and you have to put a surety that if your child don't pay, you'll be the guarantor. Or when you tell the lender, hey, lend money to someone, if that person don't pay, I paid it. So that's surety. And that must be in writing to be enforceable. So it's more to a contract than
Real property.
real property. So that's why I strike A. And now when I read it, I look for terms of art. And I look at the for term art to strike it. The sublessee constitutes a novation. Okay. So a novation is also another terms of art. And a novations is not really test on landlord and tenant, it's also test on the contract. When the buyer and the seller have a contract, okay, and then they could not perform in that contract, and they have a second contract under the second contract to modify it, a novation. And so when I see the novation, I also think about I also think like consideration or something like that, but for contract, but that's not here. This is landlord and tenant real property. So I strike B.
So they wouldn't, you don't think that the bar examiners would test us on a novation under real property?
No, because novation is a contract kind of thing, right? Buyer and seller, promisor and promisee, not landlord and tenant.
Okay.
And that's good that we talk about that. Okay, that's good that we talk about that. Okay, now sublessee is not in privity of contract. Okay, privity of estate and privity of contract. Okay, so here it gets so many terms of art, privity of estate and privity of contract. It has so many terms of art that is under the umbrella of landlord and tenant. I don't strike it.
Yeah.
See, the terms of art fit under the umbrella of landlord and tenant. You leave it alone. Because when we read A, B, C, and D, is to strike.
Yeah.
The sublessee rent payment for the tenant fully discharged the sublessee obligation to pay rent to the landlord. And this, remember, I told you over and over, the bar examiner always throw in a sentence that is outside the contract.
Yeah.
See, outside the contract, you pay someone else, you didn't pay me. So these is always those kind of sentences that I told you that interject in, that is you know why you pick D? Because you are humanistic. You don't want to punish the sublessee again because he did make payment.
Right.
I said, well, Mr. V, he did make payment. It's not his fault. Well, we are lawyers. Yeah. We follow the terms of art. We follow the term of contract. We make them have a duty. We follow that. You know, your duty is to pay to the landlord. So the sublessee pay to the wrong person because the sublessee did not hire a lawyer, form a contract with the tenant, and made a contract with the tenant that he will pay the tenant. Well, you have a contract with the tenant, and now you want me as a landlord to be bound by the contract that you signed with the tenant that I have no idea what's going on.
Yeah, no.
So remember, the bar examiner always throw that kind of sentence in there.
Well, you already came to the right conclusion without even reading the facts in your method.
And you guys know this over and over. It's over and over. It's because you remember you have to break up the snake part.
Yeah, I think I need to go over, make sure I read over, break down my outline and look at what's under my umbrella, because that helped me a lot.
And read it a lot. And then also any terms of art under that outline that you don't know, the snake you don't know, look it up. Or that I have not talked about.
Yeah.
Okay. Thanks a lot.
Thank you, Mr.
Okay, I see you tomorrow at 9.
Okay.
Yes.
Bye.